In a dramatic evidentiary ruling that nearly collapsed the prosecution's case mid-trial, Norfolk Superior Court Judge Beverly Cannone excluded key testimony from a Commonwealth expert on dog bite marks on John O'Keefe's arm, after defense motions argued it was unreliable junk science under Daubert standards. This decision, issued in the retrial's evidentiary phase in spring 2025, stemmed from challenges to the bite analysis linking the injuries to the Albert family's German Shepherd, Chloe. Prosecutors claim the marks showed O'Keefe was attacked by the dog inside the Albert home before being placed in the snow. But wait. No. Actually, the prosecution's theory was vehicular strike, and defense used the dog bite theory to suggest a fight inside. Let's clarify. Defense argued the arm wounds were dog bites from Chloe, supporting their third-party culprit frame job, while prosecutors attributed abrasions to taillight shards from Reed's SUV. The exclusion limited defense's ability to fully present alternative explanations, but Cannone allowed general testimony on scratches, forcing both sides to adapt. Prosecutors pivoted to emphasize vehicle data, while defense hammered investigative biases. This ruling underscored the case's heavy reliance on disputed forensics and circumstantial proof, highlighting how evidentiary gatekeeping can sway outcomes in a polarized trial. As we'll unpack in depth, this tightrope, combined with jury instructions on third-party culprit evidence and consciousness of guilt, contributed to the jury's acquittal on all counts, raising questions about appellate review standards if the Commonwealth seeks to challenge procedural errors. To fully grasp the courtroom strategies, we must first outline the case's factual backdrop, drawn from trial transcripts, public filings, and judicial rulings. The charges against Karen Reed stemmed from the tragic death of her boyfriend, Boston police officer John O'Keefe, on January 29, 2022. O'Keefe was discovered unresponsive in a snowbank outside 34 Fairview Road in Canton, Massachusetts, the home of fellow Boston police officer Brian Albert and his wife Nicole, following a night of bar hopping and an after-party. Prosecutors from the Norfolk County District Attorney's Office, led by Michael Morrissey, alleged that Reed, after a heated argument with O'Keefe, struck him with her black Lexus LX 570 SUV while reversing at high speed during a three-point turn, then fled the scene, leaving him to succumb to blunt force trauma and hypothermia in blizzard conditions. Red maintained her innocence, claiming she dropped O'Keefe off safely and that he was beaten inside the Albert home during a fight, with evidence planted to frame her due to law enforcement connections and cover-ups. Reed was indicted in June 2022 on 3 counts: second-degree murder, Massachusetts General Laws, Chapter 265, Section 1, manslaughter while operating a vehicle under the influence, Chapter 90, Section 24G, and leaving the scene of an accident resulting in death, Chapter 90, Section 24. The first trial, beginning April 16, 2024, spanned 29 days of testimony before ending in a mistrial on July 1, 2024, after the jury reported irreconcilable deadlock. Post-mistrial, Reed's defense filed motions to dismiss the murder and manslaughter counts, arguing partial acquittals based on juror notes. But Judge Cannone denied this on August 9, 2024, a ruling upheld by the Massachusetts Supreme Judicial Court in December 2024. The retrial commenced on April 1, 2025, lasting approximately 9 weeks, with over 70 witnesses, expanded from the first trial, and more than 650 exhibits, including enhanced forensic analyses. Jury selection was exhaustive, involving individual voir dire questionnaires to mitigate bias from extensive media coverage, social media campaigns, e.g., the Free Karen Reed movement with rallies, fundraisers, and documentaries, and public polarization. The final panel consisted of 12 jurors, 7 women, 5 men, and 6 alternates, drawn from Norfolk County. Opening statements crystallized the dueling narratives. Assistant District Attorney Adam Lally portrayed Red as an enraged, intoxicated driver who committed a senseless act of violence amid relationship turmoil. Defense attorney Alan Jackson countered that Karen Red was framed by a cancer of lies from conflicted investigators tied to the Albert family, urging jurors to see the case as a botched probe rather than murder. Under Massachusetts law, to convict on second-degree murder, prosecutors bore the burden of proving beyond a reasonable doubt three elements. 1. An unlawful killing. 2. Committed with malice aforethought, defined as intent to kill, intent to cause grievous bodily harm, or intent to act with extreme recklessness, creating a plain and strong likelihood of death. And 3. Causation linking the defendant's act to the death. Malice, a key legal concept, is not synonymous with ill will, but focuses on the defendant's mental state, purposeful or recklessly indifferent conduct. Evidence of malice often derives circumstantially from the nature of injuries, weapon use, here, a vehicle, and post-act behavior. For manslaughter, while OUI, elements include 1. Operation of a motor vehicle, 2. On a public way, 3. While under the influence of alcohol, blood alcohol content over 0.08% or impaired ability, 4. In a negligent or reckless manner, and 5. Causing death. Negligence requires showing a want of due care, while recklessness elevates to disregard of probable harmful consequences. The leaving the scene charge demands proof of 1. Operation causing injury, death, 2. Knowledge thereof, and 3. Failure to stop, identify, or aid without excuse. Intent and knowledge were fiercely contested. Prosecutors inferred malice from Red's alleged statements, I hit him, angry voicemails, e.g., John, I fucking hate you, and a 22 blood alcohol level extrapolated from hospital tests hours later. Defense argued these reflected distress, not confession, and challenged impairment evidence as speculative. The evidentiary foundation relied on a mosaic of physical, digital, and testimonial proofs, scrutinized under Massachusetts rules of evidence. Central exhibits included Reed's SUV, impounded and forensically examined. Its right rear taillight was shattered, with plastic fragments recovered near O'Keefe's body, matching via chemical analysis. Fourier transform infrared spectroscopy. Vehicle telematics data from the Lexus black box recorded a reverse maneuver at 24.2 knot-rp for 62.5 feet at 12:24 a.m., aligning with prosecutors' timeline of impact. O'Keefe's autopsy, performed by Dr. Irini Scordi-Bello, detailed cause of death as blunt force head trauma, skull fractures, brain swelling, compounded by hypothermia, with arm abrasions containing red plastic consistent with taillight debris, no internal injuries typical of low-speed pedestrian strikes, a point defense exploited. Digital evidence was pivotal. O'Keefe's iPhone Health app logged 80 steps between 12:21 and 12:25 a.m., suggesting movement post-drop-off. But prosecutors claimed this reflected being dragged or struck. Reed's phone showed 53 calls to O'Keefe overnight, a 6:23 a.m. Google search for hose long to die in cold. Timing disputed, defense alleged witness Jennifer McCabe conducted it earlier, and location data placing her at the scene. Bar surveillance videos and receipts documented the group's intoxication at the Waterfall Bar and C.F. McCarthy's, with Reed consuming 7 vodka sodas. Ancillary exhibits included snow samples, no blood dilution consistent with defense's drag theory, O'Keefe's clothing with abrasions, and inverted security footage from the Albert home showing no external activity. Prosecutors methodically presented these via expert witnesses, projecting diagrams and animations in court to trace the sequence: argument, strike, abandonment. Witness testimony amplified the evidence, with over 50 for the prosecution. First responders, like Canton firefighters Matthew Kelly and Anthony Flamati, described finding O'Keefe buried in snow, unresponsive with facial swelling and arm wounds. Carrie Roberts and Jennifer McCabe, who discovered the body with Reed at 6 a.m., testified to Reed's frantic statements. Did I hit him? Could I have hit him? And her CPR attempts. McCabe detailed the Google search on her phone, claiming Reed requested it amid panic. Defense cross-examined on deletions and timing, suggesting fabrication. State Trooper Michael Proctor, the lead investigator, faced intense scrutiny. His derogatory texts about Red, whack job, hopes she kills herself, were read aloud, undermining credibility and supporting defense bias claims. Crash reconstruction experts from ARCCA, hired by DOJ and state police like Trooper Joseph Paul, opined the taillight damage matched a pedestrian impact, with biomechanical analysis showing O'Keefe's injuries consistent with being thrown backward at speed. Dr. Marie Russell, a retired physician, countered defense's dog bite theory, attributing arm marks to raking rather than bites. The OUI manslaughter theory introduced felony-level risks, 5 to 20 years, while murder carried life without parole eligibility for 15 to 25 years. Prosecutors' multi-prong approach, intentional strike or reckless OUI, was risky, as it allowed jurors to compromise on lesser charges but also invited doubt if evidence didn't uniformly support malice. The third-party culprit element added complexity. Defense's frame job theory implicated Albert family members and associates, e.g., Brian Higgins, Colin Albert, in a beating, with evidence planted via solo cups and taillight pieces. This novel defense, permitted under Commonwealth v. Bowden, required prosecutors to disprove alternatives beyond reasonable doubt, a high bar in circumstantial cases. Jury instructions, delivered on June 13, 2025, after a contentious charge conference, were instrumental. Judge Cannone's hour-long charge, based on Massachusetts Superior Court model instructions, defined elements meticulously, malice as frame of mind, which includes not only anger, hatred, and revenge, but also every other unlawful and unjustifiable motive, causation as proximate cause without superseding interventions, OUI impairment as diminished capacity to operate safely, with presumptions from BAC evidence rebuttable. Critically, on third-party culprit, Cannone instructed, "You may consider evidence that someone other than the defendant committed the crime if it creates a reasonable doubt as to the defendant's guilt, but cautioned it must be more than speculation," drawing from Commonwealth v. Silva Santiago, 2009. She allowed consciousness of guilt instructions for Reed's statements and actions, but with caveats. Such evidence is never sufficient in itself to establish guilt. Defense objected to omitting stronger language on investigative inadequacies, Bowden instruction, arguing it diluted doubt. Cannone overruled, citing evidentiary sufficiency. Prosecutors sought limits on Proctor's texts as hearsay, but Cannone permitted them for bias. Jurors received written copies, facilitating 5 days of deliberations before the June 18, 2025, acquittal on all counts. The defense strategy masterfully sowed reasonable doubt through a conspiracy narrative, avoiding a full case presentation to keep the burden on prosecutors. Attorneys Jackson, David Yannetti, and Elizabeth Little conducted aggressive cross-examinations. Proctor was eviscerated as compromised, with texts revealing ties to Albert's. McCabe's search was portrayed as planted, with CERT team searches of her phone questioned. RK experts recalled in a heated hearing admitted limitations in their models, unable to rule out non-vehicular causes. Defense witnesses, though limited, were impactful. Biomechanics expert Dr. Andrew Rentschler, independent, testified O'Keefe's injuries mismatched a SUV strike, no lower body trauma, head wounds more consistent with falls or blows. Canine forensics consultant disputed bite exclusions. In closings, Jackson thundered, "This was a cover-up from start to finish, taillight planted, witnesses coached, evidence inverted." They leveraged the beyond a reasonable doubt standard, urging acquittal if any alternative lingered. Post-acquittal, the case's legal ripples continue, though double jeopardy bars retrial. The Commonwealth filed no direct appeal. Acquittals aren't appealable. But Reed pursued civil claims against investigators for malicious prosecution, with motions pending as of January 2026. Earlier appeals on mistrial dismissal were mooted, but the SJC's December 2024 ruling on partial acquittals sets precedent for hung jury interpretations. Defense highlighted due process violations, biased probe, potentially influencing federal habeas if needed, though unlikely. No significant state-federal jurisdiction clashes emerged, but the case spotlighted conflicts in police-involved investigations, prompting a DOJ probe into Canton PD practices. In conclusion, irrespective of perspectives on the verdict, this case's legal significance endures. It probes evidentiary standards for forensics in vehicular homicides, the scope of third-party culprit defenses amid public scrutiny, and appellate handling of mistrials. Prosecutors' circumstantial web, contrasted with defense's doubt amplification via institutional distrust, illustrating how technical rulings can dismantle complex theories. As civil proceedings advance, it may reform investigative protocols for officer deaths. Thank you for joining me on Courtroom Unfiltered. If this in-depth analysis resonated, please like, subscribe, and share for more objective legal breakdowns. I'm your host, Sarah Ellis. Until next time.